Hello, I'm Ian Larkins from Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. Data security continues to be a hot topic. Now, we reported last month on the new European data protection law that will be introduced in 2018 and will hike potential fines up to 4% of turnover. The Information Commissioner has also been keen to highlight that the financial damage does not stop at the fines. The goodwill loss may be more. A recent YouGov poll reported that 20% of people had said they would definitely stop using a company's services after hearing news of a data breach. The provision of Wi-Fi is now commonplace in public spaces, but when Wi-Fi location analytics are used to track consumer behaviour, careful consideration needs to be given to the data protection implications. The Information Commissioner Officer has issued guidance on this topic to help Wi-Fi providers ensure they remain compliant with data protection laws. The guidance is available on the ICO's website and states, amongst other things, that Wi-Fi operators should be clear and transparent about the identity of the data controller, the defined purpose of the data processing, and information relating to any third parties or other organisations that the data may be shared with. The invalidation of the safe harbour regime in late 2015 has been the big news in data protection for the last 2 months. Safe harbour allowed companies to transfer personal data to US safe harbour registered companies and comply with data protection law. There is now a safe harbour replacement known as the EU-US Privacy Shield, although this has not yet formally been approved by the European Commission. We remain therefore in no man's land, but as we have previously reported, the ICO has provided reassuring words that it is not likely to take enforcement action against a company that unwittingly finds itself in breach of data protection law simply because of the safe harbour revocation. So until the EU-US Privacy Shield is approved, we recommend that companies assess any of their personal data transfers to the US. If they believe there are risks to personal data, then alternative forms of protection should be considered. There is interim guidance on the ICO's website, and we do hope that we can bring you more certain news in our next bulletin. The ICO has launched a self-assessment tool to help small and medium-sized organisations assess their compliance with the Data Protection Act. The tool is available on the ICO's website. We've been testing the tool in the last couple of weeks and are impressed with it. It provides useful links to relevant guidance and will generate a rating based on responses. The ICO has issued a new draft Privacy Notices Code of Practice for consultation. The code focuses on best practices for ensuring that individuals providing personal data to companies are provided with clear information about how their data will be used. The code suggests including just-in-time pop-up notices and the use of video. Advice is also provided on how better information on smaller devices such as smartphones and tablets is provided. The ICO is seeking feedback on its consultation, and that's running until the 24th of March. The Advertising Standards Authority, the ASA, has issued guidance on how it works and that it has formed a new partnership with Camden Council's Trade and Standards team to provide the legal backstop for the ASA. The guidance explains the situations in which the ASA will refer advertisers to Camden and notes that Camden has the authority to issue on-the-spot fines that can be for several £1,000s. Free guidance on advertising is available from the Committee of Advertising and Practice team. Despite a legal requirement for the government to implement pay gap reporting by March 2016, it seems that the Equality Act 2010 Gender Pay Gap Information Regulations of 2016 will not become law until October this year, with large employers, that's employers of 250 or more people, being required to do a data snapshot on the 30th of April 2017 and then secondly publish their first gender pay information by the 30th of April 2018. It will then be an annual publication requirement. The government is currently consulting concerning the detail of the data that will need to be published. We have previously reported on the long-running commission pay saga. The issue here is whether employers should take into account commission payments when calculating holiday pay and therefore ensure employees are not discouraged from taking holiday. The lead case of Locke v British Gas has ruled last year that holiday pay must take account of commission payments. This was subsequently appealed by British Gas to the Employment Appeal Tribunal, the EAT, but the appeal has been dismissed. We now wait to see whether British Gas is willing to roll the dice again and take the case to the Court of Appeal. Any appeal is unlikely to be heard until early 2017. It had previously been considered that payments for injury to feelings paid in connection with a termination of employment was not taxable. However, this view has been turned on its head in an upper tribunal decision in the case of Muti v Commissioners for the HMRC. In this case, Muti brought a claim for unfair dismissal and age discrimination. Now, there was no allegation of discrimination prior to termination. The upper tribunal ruled that injury to feelings payments made in connection with the termination of employment are taxable. The income tax exemption does not apply because injury to feelings is not an injury for these purposes. This does not, however, change the first $30,000, which we understand can still be paid tax-free. The upper tribunal has also acknowledged that the compensation paid in respect of discrimination during employment unrelated to the termination is not taxable. This leaves us with considerable uncertainty. The HMRC is likely to follow the upper tribunal decision, although it is not binding on the Employment Appeal Tribunal. An appeal is likely at some point to hopefully provide clarity that is now needed. A recent case of Barbulescu v Romania has been reported widely and we believe may have given some false comfort to employers wishing to intercept their employees' messages. In this case, an employee was dismissed for using his employer's internet for personal use during working hours. The employer had obtained evidence by accessing the employee's Yahoo Messenger account. The case, which reached the European Court of Human Rights, determined that the employer's interception was proportionate. This case does not, however, give employers a free rein to monitor employees' personal communications. In this case, the employer had a ban on all personal messages and this policy had been widely communicated. The private messenger account was set up specifically for business purposes. Now, any monitoring of personal emails must be considered on its own circumstances. Guidance on monitoring employees is available on the ICO's website. The Nestlé and Cadbury spat concerning the Kit Kat 3D shape mark has been rumbling on for over 4 years now. After referring some questions to the Court of Justice of the European Union, the CJEU, the High Court ruled that the Kit Kat shape mark failed the test for distinctiveness. The test for acquired distinctive character is whether the goods or services are designated exclusively by the mark. The Kit Kat shape mark may have failed here because the shape is actually covered by the wrapping and is recognised more by its bold red branding than by the shape itself. If a party wishes to gain a trademark for a shape, it will therefore be important to establish awareness of the shape independently of any other branding. In this case, perhaps by advertising the Kit Kat without any packaging. Now, a similar decision has also been reached in the recent case of the London taxi company LTC v Fraser Nash. In this case, LTC claimed that Fraser Nash had copied its London black cab. The court, however, dismissed LTC's claims and stated that LTC's shape marks should not have been registered as they lacked the required level of distinctiveness. The Online Dispute Resolution, ODR, had a delayed start but was finally implemented on the 15th of February. The ODR platform creates a process whereby any consumer that is dissatisfied with goods or services purchased online in the EU can log on to the ODR platform and complete an electronic complaint form. The relevant trader will then need to propose an alternative dispute resolution provider. If an ADR provider cannot be agreed, the complaint will not be progressed any further. Online traders selling to consumers must now provide an electronic link on their websites to the ODR platform, state their email address on their website, and include a link to the ODR platform in their general terms and conditions. The ODR regulation is just one part of the European-wide project on consumer protection, and the European Commission is now conducting a fitness check to evaluate the value of EU consumer law policy. The National Audit Office, the NAO, has recently published its report on the UK Competition and Market Authority, the CMA's performance. Its report highlights that CMA needs to increase its flow of successful enforcement cases. The report notes that the CMA's aggregate fines of £65 million imposed for cartel infringements between 2012 and 2014 is significantly lower than its German equivalent that imposed almost £1.4 billion of fines over the same time period. We are aware that the CMA has increased its resources recently, so do expect to see more activity. Now, since the issue of the NAO report, the CMA has already added to its fines pot by issuing fines of £45 million to GlaxoSmithKline, GSK, and the successor companies of Alpharma Limited. Now, in this case, GSK held patents to a drug that Alpharma wished to bring in generic equivalents. GSK threatened litigation, but settled when Alpharma agreed to delay the introduction of its products. Now, clearly this case and similar cases pose a challenge to patent owners. Settling out of court may lead to a competition law fine, so do all such actions now need to be litigated to reach a court decision. Thank you for joining us for this month's commercial bulletin. Please feel free to contact me if you'd like more information on any of the topics covered, and if you've not already done so, you can get access to more content with Lexus PSL. Any other feedback on our bulletins is, of course, also welcome. We'll be back next month with another update. Until then, thank you and goodbye.